Hi, welcome back. The jury is on break right now for lunch, and we're being told that there could be a possibility of only 2 more witnesses, believe it or not. This case has gone in pretty quickly, by my estimation, that may testify for the government. And if it's true from what we're gathering, what we're learning, kind of interesting, and maybe another use of force witness. Again, I get back to, too many cooks may spoil the broth. Nevertheless, maybe the government wants to end with that witness, and then possibly one of those spark of life witnesses. That would be the brother of George Floyd. That would be certainly a good way to finish for the prosecution. It means so much. But we've got another one of our boots on the ground, Brian Buckmeyer, who's breaking this all down. You guys are doing such a great job out there, Brian. What do you got for us?
Thanks, Bob. So, as many of you have heard, yesterday there was some protesting and riots after the shooting of a 20-year-old boy, young man, and that kind of spilled a little bit into the courts here today. Of course, Eric Nelson talking about sequestering and also wanting to voir dire the jury about what happened last night, even spilling into early this morning. The judge denied that. Then we heard testimony from a cardiologist, but even from the pool reports inside the room, there was an increased presence of National Guards. And of course, as you said, we're expecting Felonious Floyd to testify later today. From the pool reports, it appears that it's very similar to the last couple of days of testimony in that the juror seems to be very attentive to what Attorney Blackwell is saying and also parts of his direct and redirect. And they started to slow down a little bit on their note-taking, when it came to Eric Nelson.
Yes. Brian, were you surprised at all with regard to the sequestration discussion as well as voir diring the jurors that the judge denied both of those motions?
Not so much in the denial. I'm actually surprised that Eric Nelson didn't go a little bit further and maybe even bring up the magical word of mistrial. I would have anticipated that if he did have an opportunity to voir dire some of the jurors, that might have come up. He would have maybe tried to lay the foundation for that. But I think what he was ultimately getting at is that there's a fear that this could lead to a mistrial. And I would have thought he would have led with that language and then explained why he needed to voir dire, explain why he needed to have these jurors come forward and talk about what happened last night and this morning.
Yeah, so I mean, but the record clearly is being made by this defense attorney, Brian. In your mind, I would imagine this will be, if there is a conviction, a big issue on appeal. Does it have any legs?
I'm not sure if it has a legs because I think and what you see oftentimes in appeals court, they'll argue, well, okay, then anytime an unarmed black person gets shot in the middle of a trial of an officer shooting and killing or kneeling and killing, then we have to voir dire the case. I mean, in the last 2 weeks, there have been plenty of shootings and plenty of deaths that could lead to this issue. Now, of course, the defense will say geographically, it being 20, 25 miles away from the court is very different. But I can see a prosecutor and maybe even an appellate judge saying that gets very difficult when you put it into practical measures.
Excellent. Okay. Hey, Brian, we really appreciate it. Thank you. You're always doing a great job. Hope you're having fun out there.
Appreciate it. Thank you, Bob.
Okay, you got it. And it's not just Brian that we got here, too. It's Anjanette Levy. He's going to give us a little bit of a rundown about Judge Cahill, who, by my estimation, is a really, really good squared-away judge. But the defense and the prosecution had filed numerous motions prior to this trial, including delaying the trial, moving the trial, and he just methodically went through each one of them. Let's listen to Anjanette Levy with respect to Judge Cahill.
I spoke with the chief judge of Hennepin County's district court and the former public defender for the county about what Judge Cahill is like both inside and outside the courtroom.
Good morning, everyone. We'll proceed with our next witness.
Each morning, Judge Peter Cahill warmly greets the jurors. You may have noticed some lighthearted moments with them.
Go ahead and throw me under the bus with your fiancée.
But there have also been times when it was clear Cahill was angry.
What's your connection to this case?
And he didn't hesitate to remind people that he's in charge.
And I think what we're getting into is criticizing each other's performance. Let's not do that.
Hennepin County's Chief Judge, Todrick Barnett, chose Cahill to preside over the cases of Derek Chauvin and the 3 other officers.
This moment's not too big for him.
Cahill has been on the bench since 2007, and Barnett says he has good control of the courtroom and the law.
He's going to base his decision on the law. And that decision could be unpopular with the public, but it's going to be a sound legal decision.
And I think he's done a really good job with the jurors.
Former Hennepin County Public Defender Mary Moriarty has appeared in Cahill's courtroom when cameras weren't there.
He was a prosecutor. He was a public defender. He's very conversant in criminal law, which is important. He has pretty good temperament.
That temperament has been on display for the world to see. Judge Cahill making the decision to allow the trial of Derek Chauvin to be streamed gavel to gavel, a first in Minnesota's history.
I thought that it was important that the public have access to this trial, especially with all of the media attention that it received.
Judge Barnett says that Judge Cahill is willing to chip in and help out anytime there's a colleague in need. He did so when one of their colleagues was sick. He's a husband and a father of adult children. And Judge Barnett says the two of them have actually known each other for many years because Cahill interviewed Barnett when he was getting ready to move over from the public defender's office to the county attorney's office to work as a prosecutor. For the Law and Crime Network, I'm Anjanette Levy.
Well, I'm really glad we did a spot on Judge Cahill because I think he demonstrates everything that the temperament and the knowledge that a judge should have. Let's bring into the game here Anna Yum, criminal defense attorney. Anna, I've been dying to get you on because I want to just go back a little bit about something with regard to Maurice Hall. That is the person who may and is going to assert the Fifth Amendment. Very interesting dynamic here that I think our viewers would like. Now, Mr. Hall has relevant information, was subpoenaed by both sides, but the defense wants to call him as a witness. Apparently, the prosecution no longer does. And so they sought immunity from the prosecutors. And I had a case just like this in a murder case where I sought immunity from the prosecutors. I was defending the person at the time. And the prosecutors refused to give it to me. So I was being deprived and denied a witness that could give exculpatory or information that tended to show the person's innocence. And yet there was no mechanism for me as a defense lawyer to get immunity from those witnesses. So it effectively allows prosecutors to make the decision as to who the defense will have access to and who won't. Now, I will note, Anna, that there is a case out of the Third Circuit in Puerto Rico like 50 years ago where the defense lawyer made an application to the court to grant immunity. In that case, it did. In my case, I made the argument, I lost. Is this right that the prosecutors have the ability to stop a major fact witness? This guy was right there when this incident started. Does the defense have a right to say, we're entitled to have that person come in?
I think so. I think the defense has a strong argument in saying that because exactly what you were saying, Bob, especially if there's exculpatory evidence that could be in the defense's favor. You would think that, of course, the defense's argument is, come on, prosecutor, this is about the truth, isn't it? This is about seeking the truth and justice. So why don't you let him testify? Give him immunity. Let's see what he has to say. That, of course, is the argument that Mr. Nelson is going to make. And to your point, Bob, it is true. The court cannot necessarily give him immunity here. And if the prosecution doesn't want him to testify anymore, the argument, of course, is that they have the cards. If they determine whether or not he gets immunity or not, and then, of course, that's dependent upon whether he even testifies. That is a big factor and a big argument for the defense to make, especially if there is helpful or exculpatory information for Mr. Nelson and his case.
Yeah, and I really think that they need to do something. And you talk about criminal justice reform, and people are talking about that. That's one where a defense attorney is being deprived of witness because the prosecution is blocking it because it'll hurt their case. Doc, what do you think about that issue?
Yeah, I think Anna raises a great point. It really is about the truth, isn't it? Isn't that what we're after here? And I think one of the things that's really interesting, whether you're an attorney or you're an expert and you're dealing with a situation like this when immunity is involved, is on the one hand, you don't want the individual to make a self-incriminating statement. So you want to shield him. And in fact, when I'm asked to do evaluations, one of the main referral questions from attorneys is, please do not discuss the facts of the case, because they don't want me documenting a self-incriminating statement that the defendant may offer to me and have it in writing. So that's one side of the coin. But the other side of the coin is getting back to what you're saying and what Anna was just commenting on is we are looking for the truth. We do want both sides to have a fair and impartial shot at this, and we want the jury to have all of the information. And that's why this specific decision is really, really important in terms of the jury being able to make a fair and impartial decision regarding guilt or innocence. Bob.
Yeah, Anna, what do you think about the idea of my statement? Too many cooks spoil the broth. What do you think about the potentially another use of force expert, potentially more contradictory information? We've already had a number of medical experts. Do you think it's been overkill too much, or do you think it's been needed and surgically done properly by prosecutors?
I think it's getting to the point where it is, like you said, too many cooks in the kitchen, too many cooks that could spoil the broth, especially if you have a strong witness or a couple of witnesses who can lay the proper foundation as to whether excessive use of force was used. Then why add more witnesses who are just essentially, you hope, are essentially going to say the same thing, but then give Mr. Nelson or the defense an opportunity to try to get contradictory statements, because that, of course, is what the defense's objective is going to be, to see whatever inconsistent statements they can get, whatever contradictions they can get. I am a firm advocate of you keep it simple, right? Simple and strong. But if you start adding more witnesses to the mix, that is the ultimate danger that you want to avoid. So I'm really curious to see how these witnesses are going to testify this afternoon, and whether it's going to be almost like beating a dead horse, or whether there's more helpful information to provide.
Doctor, the civil complaint that was filed in this case, interestingly, blames the Minneapolis Police Department for essentially creating a Derek Chauvin, and that it's not just Derek Chauvin. There are other officers, and that they knew the practice and policy of the departments were allowing this. They were being trained on it, and at a minimum, they knew it was going on in the field. Yet the brass came in and said, we find sanctity of life. We find that this is a murder. It was outrageous. It was excessive. Do you expect the defense attorney to be up in summation saying, Derek Chauvin shouldn't be sitting in here. The Minneapolis police brass should be the people sitting in this chair?
Absolutely. You know, it goes back to don't judge me for what I did. I'm just following orders. I'm doing what I'm trained on. But I think the key flaw in that, Bob, is the fact that, as we know, there was findings of the motions in March essentially saying that Chauvin had 2 prior incidents that are in fact being allowed in to the testimony here in the evidence, that he used use of force on an individual that was intoxicated, number one. And number two, that he understood how to go about assisting an individual who was essentially detained. And I think those 2 key issues and elements of evidence will contradict that for the jury. The defense may say, well, look, bring in the police department, bring in the chiefs. They're ultimately responsible. But I think it's a really weak argument when you go back to the individual actions of this specific officer acting in a rogue manner and really using excessive force and having a past history of excessive force. Yeah. And the best predictor of future outcome is past precedent. And that's the challenge for the defense here, in my opinion, Bob.
Yeah, but Anna, you know, to the point, in a civil rights case, you have to prove that the town had a custom practice or policy of deliberate indifference under the civil rights statute. And they do that by showing that the officers were not properly trained or they were not properly disciplined. And many of them believe that their actions were legitimate because they're never called onto the carpet. Case in point, Derek Chauvin, who not only did not get called onto the carpet, he actually got an award.
That's right, Bob. And that's why that's such a dangerous argument to make. And to the doctor's point, it is true. I mean, you're talking about Derek Chauvin, who has had a history, and that is coming in. It would be one thing if he didn't have any kind of history. And then, of course, the argument would be, don't blame him. Blame the system. Blame the processes. Blame the lack of discipline or the training. But the fact that he does have a history, I think that weakens the defense's argument. And so I'm really curious to see how Mr. Nelson is going to argue this. Is it going to be, let's focus on the theory of our case and just our theory? Or is it going to be throw the kitchen sink, throw everything up in the air and see what sticks? And that's something that could backfire if he does decide to do that.
Yeah, it'll be very interesting to see if he's going to try to tie it all in, because I'm watching his way that he goes about things as a defense lawyer, and we don't see him really flourishing and really doing a lot of showmanship, but maybe he's going to bring it all together at the end. But you know what? That civil suit was $27 million worth of them proving to the city that there was a custom practice or policy of the department to not properly train their officers. We're going to take a break, but on the other end, we're going to come back with more of Dr. Rich, the cardiologist, who was last testifying for the state. We'll be right back. Okay, so the jury is on break, and we had a cardiologist that was one of the last few witnesses that's going to testify in this case on behalf of the prosecution. And we're being advised that there may only be 2 more witnesses left, which is really miraculous given the magnitude of this case and the amount of information and data and how the prosecutor put their case together. The witnesses could be a use of force expert, another one, and one of those spark of life witnesses, which will be, as we're being told, George Floyd's brother. That certainly is a great witness to end the case with. But the state's calling a lot of medical experts. Typically speaking, it's your medical examiner who gives you an opinion about cause and manner of death. And based upon the short examination of that medical examiner, it says to me, and I understand why by looking at the autopsy report, they weren't too happy with what was written in there. So they're using other experts, in my estimation, to try to get around it. But let's listen to one of those experts, the cardiologist who testified just this morning.
Did you reach an opinion or conclusion to a reasonable degree of medical certainty as to whether either of those two causes explain Mr. Floyd's death?
Yes, I did.
Would you tell us your opinion?
Sure. After reviewing all of the facts and evidence of the case, I can state with a high degree of medical certainty that George Floyd did not die from a primary cardiac event, and he did not die from a drug overdose.
Thank you, Dr. Rich. Would you tell us what evidence or facts, documents, what did you look at to help you to reach that conclusion about primary heart event and or drug overdose?
Sure. The three aspects of the evidence that I spent the most time reviewing were Mr. George Floyd's medical records, the videos, the different angles from the day that he died on May 25th, 2020, and the autopsy report.
So the medical records, the videos, and then the autopsy report.
Yes.
Let's start with the medical records then of those three. Would you tell the jury what you were looking for in the medical records?
Sure. So you get the medical records. It's usually pretty thick, but you take it one page at a time. And at the outset, I was looking to see if he had been diagnosed with any medical conditions. That's sort of the first step. Kind of just what you do with a patient in the office, sort of what medical problems do you have? And so I was looking to see initially what diagnoses George Floyd may have previously been diagnosed with.
And what were your takeaways then from having looked at the medical records and done this assessment?
So at that level, I felt pretty confident that Mr. Floyd had three medical problems. Number one, he had hypertension, high blood pressure. Number two, it appeared to me that he may have suffered from anxiety. And three, it looked like he also struggled with substance abuse.
Annie, can you please explain to me why yet another medical expert, this one a cardiologist, is testifying about cause of death, which is a specialty of forensic pathologists?
Yes, I can. To the best of my knowledge, Bob, it's what you were saying before. The prosecution is not happy with Dr. Baker. They're not happy with the county medical examiner's autopsy report. And if you think about it, think about how they strategized this. They put Dr. Baker in the middle. They sandwiched him in with some other doctors. First, you had the pulmonologist, Dr. Chauvin. Then you had the female doctor. She was the one who had been practicing for 37 years. And then they put Dr. Baker, and now they're finishing off with a cardiologist. And so they're sandwiching him in for a purpose because they're not happy with what was in that autopsy report. And if you think about Dr. Baker's testimony, he stood by his report. He did not vary from that report. And so what they're trying to do is of course, trial strategy. You start with the strong, you end with the strong, and you put the weakest points in the middle. That's the reason why, in my opinion, I think Dr. Rich is testifying now.
I agree 100%, including sandwiching them in there to kind of mix it all up there. But Doc, does that not seem obvious to the jurors in your mind that they're going to be wondering why it is that this medical examiner, who, by the way, happens to be the president of the medical examiners throughout the country, that they need to get someone else? Do you expect that the defense is going to really drill that in summation?
I think they're going to try. And I think these jurors know that, or they're going to question the fact that this particular witness was essentially, as Anna was saying, stuck in the middle. And, you know, the bottom line is when a doctor who's a cardiologist is talking about anxiety as a cause or as a prior condition, you know, it also speaks to the fact that they're really trying to uncover Mr. Floyd's, you know, plethora of issues and then trying to connect the dots here, which is very confusing, I think, for the jury. So to your point and to your question, I think the jury will question why this particular expert was essentially sandwiched in the middle, and how much credibility to really give or weight to give his testimony in drawing their ultimate opinion on guilt or innocence here, specifically in relation to, was it cardiopulmonary asphyxiation? Was it strangulation? But let's really focus in on the expert that we can truly believe is credible, and not someone that seems to waver or comes across as certainly not credible or lacks certainty in their opinion.
Yeah, and Anna, to that point, though, they have to start picking. And as a prosecutor, you don't want people starting to pick and choose between your experts. Usually, cause of manner of death is not something that is argued. So, is this something that could potentially spark reasonable doubt?
It might, and that's what Mr. Nelson is definitely, in my opinion, going to harp during his closing argument. He's going to likely say to the jurors, "We know we can use our common sense here. Why do you think that they put Dr. Baker in the middle? They put him in the middle because they didn't like what he had to say. And who are you going to rely upon? You're going to rely upon the actual county medical examiner who performed the autopsy. One of the doctors hadn't even examined George Floyd's body. So you know that he's going to harp on that in closing argument. And that's going to be one of the weakest points, in my opinion, for the prosecution, in that what should have been their star witness is not giving them the evidence that they necessarily want.
Yeah, and let us not forget that the defense has a case to put on too, and it's experts. So it's going to be it's really a fascinating case in so many ways. Let's listen to the cardiologist as he's talking about Mr. Floyd not having heart disease.
Did Mr. Floyd have any diagnosis of heart disease while he was still alive?
No, he did not.
So you said you looked at the medical records not only for diagnoses of pre-existing conditions, but also for evidence of medical encounters?
Correct.
And by that you mean hospital visits, clinics, etc.?
Emergency room visits, exactly.
What did you find in that regard?
So this is, in my opinion, was a really important part of the review as well, because every time Mr. Floyd had an encounter with a medical professional, I viewed that as an opportunity to see if there was any signs, symptoms whatsoever, even subtle, that could have indicated, for example, that he had anything going on with his heart. And so at the emergency room visits, he had one prolonged hospitalization. I really tried to take a look at everything. I looked at any opportunity I could to see if he ever complained of chest pain, which he did not, palpitations, which is a fluttering sensation of the heart. I reviewed all of the documented physical examinations of his heart to see if there were any abnormalities noted, and there were not. No murmurs, nothing found. I looked at all of his labs that get sent to see if there were any cardiac markers of injury, which he did not have. I reviewed his EKGs and his other tests. I tried to be as thorough as possible because I view what we do as a clinician in some ways as actually being a bit of a detective.
Doctor, I don't know why this case is reminding me of the OJ thing, here, where you have experts that are contradicting each other and the jury just can't really come to a conclusion here. This defense lawyer, Mr. Nelson, did a very good job, even though he ultimately answered no, by saying, but it's not about singular things. First of all, what about the 75%, 90% occlusion of the major arteries of the heart in combination with what the medical examiner in a note that the defense has says there was a toxic level of fentanyl, the use of methamphetamine from the street, which he even admitted is not a good thing. He also admitted that you can't even tell about what the combination of those drugs would do, including high blood pressure and adrenaline, basically being arrested. That's a combination of those factors. Is the jury seeing that, or are they accepting this witness's conclusion in your mind?
I think they're listening, Bob. I think they're listening because what they're hearing from the defense's strategy is mitigate the damage, mitigate the damage, mitigate the damage. It's a combination of things that in the jury's mind or a potential juror's mind is causing them to question the idea of absolute strangulation versus these pre-existing conditions, the toxicity. That word in and of itself would raise concern if you're a juror to say, oh, this man was predisposed potentially to some sort of traumatic respiratory cardiac issue. And so the fact that the defense can't hone in on his emotional state or his anxiety, didn't get into substance-induced psychosis with methamphetamine, the fact that they're really keying in on this autopsy report and these other pre-existing conditions and combinations, I agree with you, Bob. It's a very effective strategy of planting the seeds of mitigating the damage for each potential juror in this case. And in that regard, the defense has been quite effective, in my opinion.
Well, effective because Anna, it could be considered an unforced error. Just like when you had the one pathologist from Hennepin County that works with the the person who did the autopsy, the doctor who did the autopsy says, well, with strangulation cases or cases like this, you may not see injury to the tissue or the subcutaneous tissue or in the muscles which were dissected. That can happen. She almost made it sound like you just don't know, maybe, maybe not. And this guy, the head medical examiner, basically came out and said, who did the autopsy, you would expect if it's at a level of force sufficient enough to kill a person, you'd see injury. Is that not an unforced error?
That's right. That's absolutely right, Bob. And what Eric Nelson is doing is he's planting the seeds of reasonable doubt. That is what he's doing. He is just trying to get seeds of reasonable doubt to plant in the minds of the jurors to say, look, you've heard from so many different experts in this case. And of course, you hear inconsistencies. Like you said, one of the doctors is saying you won't necessarily see bruising or for strangulation marks. But then you heard it from the actual medical examiner who performed the autopsy that if we're talking about that level of force, you likely would see some sort of physical manifestations, whether it's abrasions or bruising. And another thing, and I'm sure you've noticed this, Bob, is that he's also saying he's getting these experts to admit, well, there's no safe level of controlled substances, right, if it's not prescribed. And every expert is saying that, correct. Any level of methamphetamine is not considered safe. Any level of fentanyl is not considered safe because he's using these points so that he can argue in closing argument. These experts were all consistent with this. Methamphetamine, fentanyl, no matter what the levels, they are not safe. And of course, he's going to try to articulate that in explaining what their theory of cause of death is.
Okay, excellent job, guys. Well, we are on break now, but we expect only 2 more witnesses before the state rests its case. It may all be done today, so don't go anywhere. We're going to have more of Dr. Rich's testimony on the other end of the break. Please stay with us. All right, so we have been talking about Dr. Rich and the testimony this cardiologist gave on behalf of the state. It's probably the last medical witness they're going to have, talking about the cause of death, which is usually left to relegated to the medical examiner in a case, and indicating on direct examination that Mr. Floyd would not have died if it hadn't been for the 9 minutes and 29 seconds. Let's take a listen.
So at the time then that Mr. Floyd was actually put into the ambulance from the scene, in your opinion as a cardiologist, what would have been the prospects of resuscitating him at that point?
Overruled. You may give an opinion if you have one.
So at that point, I think the chance of meaningful survival, unfortunately, was very low because I counted the number of minutes that he was on the ground, pulseless, without any CPR. And by the time the paramedics rushed in to get him and to get him onto the stretcher into the back of the ambulance, at that point, a lot of time had passed. I give tremendous credit to the efforts of the paramedics and the doctors and nurses in the emergency room. I mean, they worked on him for what seemed...
Sustained. This is non-responsive.
Dr. Rich, do you have an opinion to a reasonable degree of medical certainty as to whether Mr. Floyd would have lived if not for the 9 minutes and 29 seconds of subdual and restraint?
Objection.
Overruled if you have an opinion.
Let me finish my question for you, Dr. Rich. Do you have an opinion as to whether George Floyd would have lived if not for Mr. Chauvin's subdual and restraint of him for 9 minutes and 29 seconds on the ground?
Yeah.
Overruled. A reasonable degree of medical certainty.
Yes, I believe he would have lived.
Last question, Dr. Rich. Do you have an opinion as to whether a completely healthy George Floyd, that is, any healthy human being, would have survived the subdual and restraint that Mr. Floyd suffered during the 9 minutes and 29 seconds on May 25th of 2020?
It's sustained as irrelevant as to a general person.
I'm sorry, I couldn't hear you.
Sustained.
My question for you, Dr. Rich, is would any person, a healthy person, have survived the circumstances or conditions that George Floyd underwent during the 9 minutes and 29 seconds on May 25th of last year?
Same objection.
Sustained.
No further questions, Dr. Rich.
And I think it's really important to analyze this case based on what the law, the jury is going to be read at the end of the day. People see that video, they're like, oh my God, that's really horrible. But in order to get second-degree murder, they have to show that it was Chauvin's intent. It was his intention to commit an assault as opposed to his intention to make an arrest or he could have done it wrong. He could have gone against department policy, but you got to show that his mental state was his intent to do it. You have to show depraved heart for third-degree murder, evincing a depraved heart without regard to human life. But on manslaughter, you have to show culpable negligence, and the judge will define that. In this area, I suggest that the jury could come back and say, the fact that he didn't render medical attention for the 3 minutes that Mr. Floyd was no longer moving is in fact culpable negligence. What do you think?
I agree. I think the same thing, especially after hearing, I believe it was Dr. Chauvin who first said that Mr. Floyd didn't have a pulse and that Derek Chauvin's knee was on his neck for that 3 minutes and however many seconds. You could make the argument, and I anticipate the prosecution is going to make the argument that evinces that culpable negligence here, is that he was on top of this man. He could see that he was not breathing. He could see that his chest was not moving. And the fact that he still kept his knee on the neck, that could evince, again, that culpable negligence. And of course, the prosecutor is going to just keep harping on that, not just mentioning Dr. Chauvin's testimony, but all the other experts have essentially said the same thing.
Yeah, in fact, when you have to prove a state of mind, it's difficult, and the jury will be instructed. You have to do it based on all the surrounding circumstances. Do you see, based on the entire complexion of this case, the way it's gone in, all of the angst and anger, the possibility of a compromise verdict here with the jurors? Is that a dynamic you see as a psychologist?
Well, with respect, Bob, I think going back to your specific question, intent is a very, very tricky word. When I get a case and I'm asked to opine on specific intent or provide an opinion on specific intent, I always say, wait a minute, I can opine or provide an opinion on the mental state at the time, but ultimately specific intent is a legal term. It's not a psychological or a clinical term. So to answer your question very briefly, I think the video is really going to play a key role here on jurors saying, yeah, there's all these experts and yeah, there's all this contradictory information. But to Anna's point, which I think she brings forward quite succinctly, the fact that there was 3 minutes that go by and nothing happens and no medical personnel are called to Mr. Floyd's aid, that's quite telling, and that's on camera in the video. And so jurors are not going to be able to ignore that, in my opinion. And the more and more they go over that video, the more they see that, I think they potentially could become desensitized to some of the confusion in the other experts' opinions and really focus in on what didn't happen, more so than the chaos that ensues when they're trying to dissect each specific expert's opinion, Bob. So I think that video is going to play a key role time and time again in terms of their deliberations moving forward.
Anna, I want to play a game with you. It's called, would you rather be the prosecutor or the defense attorney with each of the degree crimes? So on the second degree murder charge, would you rather be summing up as the prosecutor or the defense lawyer?
That's a tough question, Bob, because I was a former prosecutor, and as a defense attorney, I see both sides here. But I think that with the second degree, I would take the challenge. I would want to be the prosecution, especially with the evidence that they have in this case. The doctor's point is so true.
And so I assume
that video is the strongest piece of evidence for them.
So I assume that would mean that you would do second degree and manslaughter as well. Great. Yep. Former prosecutor myself. So we got that in common. Anyway, let's listen to Mr. Nelson as he's cross-examining this cardiologist with respect to Mr. Floyd's heart muscle and his vessels.
And so if a blood vessel is blocked and blood is not getting through that vessel, what happens?
Well, it depends, but I'd like to answer that for you. So in the case of Mr. Floyd, what has most likely happened, based on our understanding of coronary physiology, is precisely because he had a narrowing of up to 90% and it had calcium in it. We know that developed gradually, and the heart is fascinating in what it does. It develops what's called coronary collaterals, which means the body makes additional blood vessels so that if there's one artery that's narrow, it recruits and builds many more blood vessels to supply blood to the heart. It's actually why you are more likely to die from a heart attack if you started with a lesser narrowed artery and the plaque ruptured and blocked the vessel than if you started with a more severe narrowing, because of all these unbelievable coronary collaterals and adaptive responses that the heart does when that happens.
What is a safe dose of methamphetamine?
Prescribed?
Illicit.
I would never consider any illicit drug to be off the street that's not prescribed by a physician to be safe.
And methamphetamine is a vasoconstrictor, correct?
It often can act as a vasoconstrictor.
That means it constricts the blood vessels more, correct?
Yeah, correct. That's what vasoconstriction means. Narrows them down more.
You understand, based on the medical records, that there's prior evidence of methamphetamine use by Mr. Floyd?
Yes, sir.
And methamphetamine can cause some changes to the heart in and of itself, correct?
Correct.
In fact, it sort of ages the heart more, right?
I've never used that terminology.
Okay. What does it do to?
Okay, and I want to go with you on this. What do you think about this argument that the defendant has to be the substantial cause of death? His actions have to be the substantial cause of death. Do you anticipate, in summation, the defense attorney saying the person who is the substantial cause of death, and I know people don't like hearing this, but do you anticipate hearing it, was Mr. Floyd, who had a compromised health system, even if he knew it or he didn't know it? Mr. Floyd, who took toxic levels of drugs and mixed them in combination with other illegal drugs, i.e. the methamphetamine and the fentanyl. Mr. Floyd, who was committing an illegal act. Mr. Floyd, who resisted arrest. Mr. Floyd, that made us take him to the ground. Do you expect that they're going to say he was the substantial cause and not the use of force by the police officers?
I think that Mr. Nelson is likely going to have to make some sort of argument in that regard, but I think he's going to have to be very careful in how he says it, because if he starts victim blaming and he starts bashing George Floyd and saying that he's the problem, that he asked for it, I think that could very significantly backfire on him, especially if you get to the point that jurors are not taking notes anymore and they're not even paying attention or they're not even looking at him. Because keep in mind, he has to maintain his credibility and he wants to be able to sell to the jury in terms of what his theory of the case is. I think he's going to have to do it in a roundabout way by explaining, look, substantial cause of death here. There's a lot of factors. Remember, this is about totality of the circumstances. And you can't just sit here and ignore that Mr. Floyd had these underlying issues. I think he's definitely going to harp on it. And I think he's going to definitely argue it. It's just going to have to be very tricky in terms of how he presents those arguments.
Yeah, I agree completely. A fine line. It'll be interesting to see how he goes about it. Seems to be a pretty easy kill guy, even kill guy. So let's see how he does that in summation. We're going to take a quick break. We'll come back on the other end. Please stay with us. Okay, we have breaking news for you on that case with Dante Wright. This was an individual who was shot and killed by police about 10 miles away from the courthouse and in the area in which George Floyd was killed. It's a different police department. The mayor and the police chief have given a press conference and shown footage of body-worn camera footage of this. We warn you ahead of time, this is disturbing content, and it appears as if that the officer thought that she was using a taser, but rather her weapon, her gun, was actually fired. Let's take a listen.
Hello, everybody. We're going to go ahead and get started. My name is Mike Elliott. I'm the mayor of Brooklyn Center. Yesterday, just shortly before 2 p.m., the City of Brooklyn Center Police had a police-involved shooting at the 3600 block of Orchard Avenue. And in that event, a Brooklyn Center police officer discharged their weapon, leading to the death of one individual. The chief is going to get into the details of the event, but I will say that one officer discharged their weapon and they struck the driver of the vehicle. And following that, the vehicle traveled several blocks before striking another vehicle. The Brooklyn Center police officers who were present at the scene and who were attempting to apprehend the driver did respond with an attempt at saving the young man's life. However, the young man died at the scene. Our Brooklyn Center officers do wear body cams, and so there is body camera footage of the event. And we do plan on releasing the body camera footage today. In fact, we plan to do so here. But, you know, I want to say that our hearts are aching right now. We are in pain right now. And we recognize that this couldn't have happened at a worse time. We recognize that this is happening at a time when our community, when all of America, indeed all of the world, is watching our community, that we are all collectively devastated, and we have been for over a year now by the killing of George Floyd, and that we continue to be distressed as we go through the Derek Chauvin trial. So having a police-involved shooting happen in our community and killing a young man is heartbreaking and just unfathomable. And so our entire community is filled with grief at yesterday's police-involved shooting that led to the killing of Dante Wright, a 20-year-old young African-American male. And my hearts go out to Dante's family and to all those who are impacted by this tragedy in our community and the world over.
Oh, wow. Yes. Oh, man, Doc, you can hear she's saying taser, taser. From what I'm being told by our producers, instead of pulling the taser out, she pulled her firearm out and shot this young man. Tasers, just so everybody knows, are usually kept in your non-dominant side. A terrible mistake. Doc, what is happening here? Is this poor training, fear in the community? How do you make sense of this?
Well, I think we have to look at this as a specific incident. Certainly, we may want to camouflage this with a broad brush, but I don't think that's necessarily fair to the law enforcement officers out there who are doing their job. This particular officer panicked. And in that moment of fight or flight, she basically reacted in a manner whereby, unfortunately, she pulls out her weapon and begins shooting, thinking that it's her taser. So certainly, in terms of the level of trauma that this particular officer had, there was no reason for her to be in fear in that moment with this particular young man, sitting there, not a threat to her, leaning away from her, and she basically essentially leans in and shoots him. The bigger picture now is the fact that I'm going to get in a car as an ethnic minority and wonder if it's going to happen to me. Right. Basically, the whole aspect that we're dealing with in this country of social justice versus use of force. I think that's really the bigger issue here in terms of how we handle this as a community and as a society, Bob, moving forward.
Right. I got about 15 seconds. There's no gun that was involved in this, Anna. What are your thoughts?
I think to the doctor's point, it's absolutely right. It's just a tragedy. It's such an unfortunate situation. And to your question, Bob, I think it is a combination of fear, of adrenaline, of training. And remember, people can be trained to the nth degree, but when you're in that situation, it could be so much more difficult in terms of how you would react. So I think overall it's just a tragedy, and it's such an unfortunate event.
Yeah. And we will be covering this one gavel to gavel with the Law and Crime Network. The jury's on break, but we certainly will have more of this trial when we come back. Stay with us.